further ado, I would like to introduce our presenter for the day. We are so thrilled to have Nancy Stuver Wallingford with us. She's born on a farm in northeastern Missouri. Nancy moved to Leawood, Kansas during elementary school. She attended Christian College in Columbia, Missouri, and graduated from KU. She taught 11th grade English in Kansas City, Kansas, before attending law school at UMKC. Nancy was a family law attorney for many years, and she became a mediator in 1988 and has a family mediation practice in Kansas City, Missouri. And she is with us today to speak about how mediation helps families. So I am so thankful that you're spending your time with us this morning, and I will turn it over to you now.
Okay, thank you. I'm still a lawyer, but I don't handle legal cases anymore because after so many years of seeing firsthand the legal system and its impact on families, I just think it's not very helpful to a lot of people and not accessible to them because of cost. And mediation is a way that people can resolve disputes without going to court and without waging war against another family member. So that's why I mediate. And I'm going to just go through a regular mediation process, and hopefully perhaps a couple of you would have some issue that is present in your relationships or your life today, and perhaps we could do a short mediation here online. I'm a certified mediator through the state of Missouri and also through Jackson County. And I receive mediations either from referrals from judges or referrals from lawyers, or occasionally from the Family Court Resource Services, which is part of the Jackson County Circuit Court. And in Jackson County, there is a sliding scale where people can mediate, and their mediation fee is based on their income. And each party pays their own mediation fee based on their own gross annual income. And it is very reasonable cost. If you make less than $10,000 a year, your fee would be $35 for the 2-hour mediation. And in the state of Missouri, mediation is required in legal cases where a child is involved that involves its custody, parenting time, child support. And sometimes judges will refer not only those cases to mediation, but just a thorny case where the judge wants to try mediation as an alternative to going to court. So I received the appointment from the court, and I contact the people, 2 people, and most of the time it's a mom and dad. Sometimes it's grandparents and parents. I think those are the only variations of family members that I've had. And I communicate with people by phone or by email. I try to schedule mediations at a time that are convenient for the parties so they don't have to take off work. I do mediations on weekends, Saturdays and Sundays, and those slots fill up fast. Although people have such varied work schedules anymore, it's amazing. So it usually takes several weeks to make the contact and schedule the mediation. they come to my office. I send them a notice of the mediation by email, and it contains the address, the time, a map with directions to my office, and a copy of the sliding scale. They appear at my office, and I'm a pretty informal person, really, being raised in a small little farming village, really. And always ask if they want anything to drink, coffee, water. Some people take soda, but hardly ever anymore. And we get started. And I've been a mediator since '88, so I developed my own pattern of what to do. So most of the mediations take place in my office with both people present. Occasionally, if there's an order of protection in effect, one party will be in one room and the other party will be in another room, and it's the mediator that has to go between the parties in the separate rooms. It's called shuttle mediation. And of course, I do that, and it is effective. It's, in my opinion, it's not as effective as person-to-person mediation. And it's my own inclination that there must be an order of protection in place to justify shuttle mediation, because if someone asks that they just be in a separate room because they're uncomfortable or they're afraid of the other person, that has, it could have a negative impact on my view of both sides. What is considered income for the mediation process? Really, what monies you have coming into the household, into your personal income every month, job, disability, Social Security, rental income. I open it up, and I'm pretty informal. I say that they can call me Nancy. And if it's a mom and a dad, I just start out, I say, you're here for a parenting plan. I'm going to call you mom and dad because that's easier for me. And that's the reason you're here. If it's grandparents, then we would call them by whatever grandparent name they go by. Not everyone goes by grandma or grandpa. It could be Nana, Papa, Mimi, there's a lot of them. And I give a little intro to the mediation. I tell them who I am, that I've been a lawyer for over 40 years, actually, a family lawyer. So I've seen most of the disputes that the people are there to talk about. And that the reason I mediate is because I think it's healthier and easier and less expensive for people than the court system. And I have 4 rules of mediation. Number 1, everybody gets a chance to talk. And that's very important because I'm even-handed. I don't favor one over the other. I don't favor men over women, or older people over younger people, or younger people over older people. So number 1, everybody gets a chance to talk. Number 2, and this is very important, you cannot interrupt another person when they're speaking, because we want to get something done in the mediation. If everybody's talking at once, you don't hear the other person. Number 3, we're going to be polite to one another, just like you teach your child or your children to be polite. Number 4, I've had it a couple of years. People have their cell phones. I always silence my cell phone during the mediation. And I ask people to silence theirs. They can't keep it on, but to silence them. I had someone bring their cell phone in, which is fine. And this person secretly recorded the mediation, which I'm not sure that's so terrible if they kept it to themselves and didn't, offer it to anybody else. But this person put it on Facebook for everyone on their Facebook friends to listen to. So, of course, that's against the rules because mediation, it's confidential. Nothing is supposed to go outside the mediation walls unless the two parties agree that it can. I have to fill out forms for the court to say they've complied with mediation or they haven't. I can't even send those in unless they give me permission to do that. Since the mediation involves a child, I have had a few mediations where, it's for a dissolution, which used to be called divorce in Missouri, but not many. Usually it's about a parenting plan. So I always ask that they show me a picture of their child or children because I say it's one of the perks of being a mediator, because a mediator, the way I do it, it doesn't pay as much as being a lawyer, but I get to see pictures of these beautiful children. And they are just, all of them are just beautiful. So that kind of breaks the ice, and it also it establishes my priority in the mediation, that they're there to come up with the best parenting plan for that child. Hopefully it will be the best one for mom and dad or grandpa and grandma, but the priority is the best parenting plan for the child. Then after I see the picture of the child or children, I ask background information about the child. I get the whole name, I get the middle name, I get the birth date, because I want to make that child come as alive as possible right there, because they're the priority. And where they go to school, how they like school, what their interests are, what their activities are. And that also, it makes the parties more comfortable because most people care intensely in a positive way about their children, and it focuses their attention on the child and why they're there. Then I know nothing about these people when they come in. The only thing I know about them is their names, their case number, if they have a lawyer or not. If they have a lawyer, I know the name of the lawyer because I practiced for so long. I know most of the lawyers. But that doesn't affect me. If I do know their lawyers, I'm very upfront about how I know this person, but I don't have any financial relationship with them, and we're not social friends or anything like that. Because it's really important to people that they feel that I'm even-handed, that I'm not playing favorites. So then I get the background information about each party, and I go with moms first, I guess, just out of habit. Their age, which neighborhood they live in. I don't really ask for a specific address because sometimes that's a secret information. Where how many people are in their household. I always get the first name of any other household members or family members that are part of the household, because that household member is important to the child. I get the place of work of the parent, of the mom, and the work schedule, the days of the week and the times of day that they work. I get this same information. Then I turn to dad and I get the same information from dad or grandpa. and or grandma number 2, you know, whatever the configuration of people are that are in front of me. Then I ask each person to tell me what they want to accomplish in the mediation. Because, oh, one thing I forgot. At the very beginning of the mediation, after I introduce myself, I ask if they've ever mediated before. Most of them have not, although more and more people are saying, oh yeah, I've mediated once, like 5 years ago. And I establish that mediation is people talking to each other. It's mom and dad talking to each other, or grandpa and grandma talking to each other, whoever it is. And that the mediator is to be like a coach, a referee, or a teacher, because people don't know what a mediator does. You just facilitate people talking to each other. And in legal cases, I think it's helpful to have a family lawyer who's also a mediator, because they know the substantive law and the parameters of the law and the structure that the case falls into in the trial setting, so that the people can be assured that when they come up with an agreement, it's going to fit within the confines of what the law requires for a parenting plan. So then each person makes a statement about what they want to accomplish in mediation, and most of the time it's a parenting plan. And a parenting plan covers custody, parenting time schedule, which the statutes spell out has to cover weekly, weekend, holidays, winter break, spring break, summer, vacation. Covers child support. It covers insurance for the child. And it covers taxes, tax dependency exemptions for the child, and any other special expenses of the child. Then we start with custody, and I don't know if I'm being repetitive, if all of you understand custody law in Missouri or not, but I go through a little bit of a spiel giving them the background of custody in Missouri, because it has changed drastically over the last 15 years. I mean, drastically. When I was a younger lawyer and parents would go into court and there was a custody case, the mother in 90 to 95% of the cases got custody. And the father, usually the father, not always, but usually the father got visitation. He wasn't even called a parent. He got visitation. He was a visitor. And this is the way it was for generations, decades. And so there were many children that grew up not really knowing their dads very well. And there were dads that didn't know their children very well, and out of sight, out of mind. So in 1988, the Missouri legislature passed joint custody, but nobody knew what it meant. The judges didn't know, the lawyers didn't know, and the people didn't know. And it took about 10 or 15 years for that to change, but it did. And now the law is that moms and dads are on equal footing. They, when they walk in that courtroom, they're the same. There's no advantage given to anyone because of gender. There's two kinds of joint custody. There's joint legal custody and joint physical custody. And joint legal custody is like a meeting of the minds. It's where both parents or both custodians of the child, both parties responsible for the child, have to communicate and confer about the major decisions that affect that child. And for most kids, that's health and education. It's encouraging because younger people seem to be much more open, in my experience, to joint custody, to working with the other parent. Now, I'm not saying it's all sincere. I think most of it is, but that's just something I've noticed in my mediation practice. Then in Missouri, you have joint physical custody. And again, the preference in the state of Missouri is that the parents have joint physical custody, which the judges are told to start at 50-50 and work back from there as the needs of the child demand. And the evidence would show that the needs of child demand. And again, there seems to be a slow turn of younger parents that they want very lenient parenting time for both parents. Not always, but many times. And there's all sorts of joint physical custody schedules. If the parties live close and the child is not tiny, many people go with week by week. And then there's a schedule. They break down the week. One parent will get Monday, Tuesday, the other parent will get Wednesday, Thursday, and then they alternate the weekend. Or different configurations of that, depending on what the parent's work schedule is. I've had a number of people through the years where one parent will have a really good job, but they have to work the night shift or every weekend. And because of their work schedule, they're just really prohibited from having the child 50% of the time, because if they work nights, they wouldn't be there to take care of the child. So in Missouri, when you have joint physical custody, one parent's address has to be designated as the mailing and educational address of the child. And a lot of people still see that as the cornerstone of where the control lies. They'll control the situation if they're the mailing and educational address parent. But many times, if they have a open, lenient parenting plan or parenting time schedule, the designation doesn't have the overwhelming significance that custody designation used to have. So part of what I tell people when they're discussing joint legal custody is that two things have to exist in order for people to be able to be joint legal custodians. Number one, they have to be able to talk to each other. And number two, they have to respect the other one enough to actually listen to what the other one says. Communication skills, they really should be taught in school. Even though I was an English teacher before I went to law school, and then I was a lawyer where you talk a lot and everything. So much to communication. Let's see, since the child is away from the parent during school hours. Well, you can't look at it that way, because a child going to school that's part of real life. And it's part of being a parent is to deal with a child who's in school if they're that age. So the way the 50-50 is based on it, it really looks at overnights is the determining factor of, and that kind of ties into the child support guidelines too. That's custody, joint legal, joint physical. Then we go on to parenting time schedules, the weekly and the weekends. And most people want to, especially if the child is, I would say, under 10, they want to see or be around the child fairly frequently, of course. And so usually it's a 2-2-3, or different configurations of dividing up the week. Some people, they will, one week, mom will have Monday, Tuesday, dad will have Wednesday, Thursday, and they alternate the weekend. The next week, dad will have Monday, Tuesday, and they flip. Just to me, that would be very confusing, but it's their life, so they can. Children are, and I mean, children do not usually come to the mediation, even though people sometimes want to bring them. But, it's talking about decisions that mom and dads or grandparents or people in charge, the adults in charge make, not the children. So, although sometimes, like when they're teenagers, have a very busy schedule or special needs, and both parents or both sides agree that the child can have input, then I have talked to children in a few of those situations. And it's actually been very helpful. So then we talk about holidays, and the statutes set out what holidays to consider. And the statutes need to be updated because they don't have all the holidays of the various religions in the statutes. So there's Halloween, Thanksgiving, Christmas Eve, Christmas Day, New Year's Eve and Day, Martin Luther King, President's Day, Easter, Memorial Day, 4th of July, Labor Day, Mother's Day, Father's Day, birthdays. You're leaving out the holidays of the Muslim faith. Yesterday, I had a Buddhist in my office, and Chinese New Year's and different things were added. So you need to be very intent on dealing with your people as, unique individuals, because they all are. And that's one thing about mediation, I think, is it's true across the board. The mediator, in order for people to really open up and be honest about their issues or their feelings, you have to have a link with them. You have to make contact with them. They have to trust you to share in that regard. All sorts of ways to deal with holidays. Some people alternate holidays. Some people split holidays. If two families live close by, and you can really split holidays in a pretty equitable way and practical way. Like, let's take 4th of July, you can split it in half. It'll go from evening of 7/3 through sometime on 7/4, like maybe 4 o'clock in the afternoon. And then the other parent or party will have from 7/4 at 4 o'clock till 7:05 a.m. So each parent will have a stretch of time with the child. Some parents are not much interested in. I've had several cases where a parent doesn't celebrate holidays. I mean, there's a religion where they don't celebrate holidays. So of course, the other parent or party gets most of the holidays. So you go through that. So we've covered the parenting time schedule. Vacation, it's ordinary for parties to each receive a certain number of days of vacation every year. It depends on the vacation they get from work. It's anywhere from 5 days to 2 weeks. Some people actually, like Ford workers, they'll get a shutdown in July and a shutdown in December. So there's a big stretch of time where they can have parenting time with the child. Then on vacation, you get so many days, each parent gets so many days with the child. You can either exercise it consecutively or non-consecutively. You have to give 30 days written notice. You can text your written notice. You have to give a full itinerary of where the child's going to be and how the child can be communicated with at all times. And the vacation cannot interfere with the child's school or the other parent's holidays. That takes care of the parenting time schedule. Then we go on to the money issues. And Missouri has a child support guideline where it's presumed that the child support will be a certain figure if you follow this calculation. Again, this child support guideline was developed in 1988. And there've been a lot of changes in custody laws, parenting time laws, and the workplace since then. So even though the child support guidelines came out in 1988 and joint custody was passed in 1988, the child support guidelines didn't consider joint custody at that time. They do now, which makes it a lot more equitable. In fact, if parents have about the same amount of income per month, or parties have about the same amount of income per month, and they have close to a 50-50 parenting time schedule, there's not child support going to be paid, usually. So that's a big change, because for years it was whichever party got to the Division of Child Support Enforcement first and established a child support order, that person had the child support order and the other parent paid, no matter what the living conditions had been. So it's not that way anymore. And let's say you have a 50-50 custody plan. The non-designated parent gets a parenting time credit for the number of overnights that they have per year with the child, which reduces their child support. Health insurance, I believe I'm correct on this, that the statutes just call for health insurance for the child to be provided by the parents, not necessarily dental and vision, but many times people have the whole package. And so we calculate the cost of that. And most people just make a very practical decision which parent or party has the best coverage for the child. And the cost of the insurance, we have to delineate what is the cost only for the child on the insurance. And you have to back out the cost of the employee parent on the insurance. The dependency exemption, again, the guidelines are a little out of date on that. It's the regulations of the child support guideline give the tax dependency exemption to the designated parent. But if the people have 50-50 parenting time, you ask yourself, is that equitable? So many people will alternate the dependency exemption. So let's say the mediation has gone on and the parties have reached a lot of agreements. I take voluminous notes right there during the mediation, and the parties are free to take a picture of my notes if they want to. And I have a whiteboard in my office, and I calculate the child support right there and explain the process so people can understand the dollars, you know. And then I tell them that I will type up their agreements. It's called a memorandum of understanding, and I email it to them. And if I have permission, I email it to their respective lawyers if they have lawyers. Many or some people don't have attorneys. And I get their agreement for that. And then I tell them I'm going to fill out the forms that tells the court they've complied with the mediation requirement. And I ask their permission to send those in, and that their mediation is finished. And I haven't always done this. You know, you grow as a mediator, just like you grow as any kind of worker. And I thank them for coming, because it takes a certain amount of courage to come in there and lay yourself open to the other party if they don't have trust in that other party. So it actually is it can be personal growth for people as people and as parents. So that's my mediation practice. So any more questions?
Thank you, Nancy. I'm wondering, for kinship caregivers who are caring full time for the children, but the biological parents are still wanting to be involved from time to time in the lives of the children, what is your recommendation as far as what mediation for that family dynamic would look like?
Well, first of all, is there any court order that governs the situation?
I would say oftentimes it's an informal placement where it's just an agreement between the parents and the caregivers.
Okay. Well, mediation could certainly offer an arena for the two parties to come together and work out an informal arrangement. And the mediator's trained to, to not have one party overwhelm the other or overbalance the other. We're trained to keep the power balanced between the two. And I would say it would be a very promising opportunity for the two parties to communicate and hopefully reach an agreement. I also think that most cases could be really helped if, as soon as the case were filed, the parties went to mediation. Because sometimes I've had mediations where that's all you can do, is there'll be like a standoff between the parties. One party won't allow the other one to have contact with the child. So it puts that arena in the mediation realm, but that's the first step, is to get parenting time or grandparenting time for that party who's being denied, see? I can give legal information, which I think is very helpful. I mean, if you have a mediation case and it's based on an active case in court, and I know what the predilection of their judge is on to rule on certain things, don't you think that's important information? I might have to phrase it differently. I'd like say, well, you need to go call your lawyer and find out what their experience is with this judge and see what their experience tells them the judge would do in this case. See, you understand what I'm talking about? But I cannot give advice. I can't tell them what to do, but I can give legal information. And a few mediations, the lawyers attend, and most of the time, the lawyers have been very helpful.
Absolutely. Yes, we are so fortunate to know about these services and hear all of the great detailed information that we heard this morning. And yeah, thank you so much